Good afternoon. I'm Dean Jessica Berg, and I would like to welcome you to our Sumner Canary Lecture, one of the law school's premier endowed lectures, which brings extraordinary jurists to the school to discuss current legal issues. The lecture series was established to honor the memory of the late Judge Sumner Canary, who was a judge on the Ohio Court of Appeals for the 8th District, U.S. Attorney for the Northern District of Ohio, and a 1927 graduate of this law school. You will find a plaque in the lower rotunda recognizing Judge Canary and listing the distinguished speakers who've joined us over the years. The lecture is made possible through the generosity of Judge Canary's widow, Nancy Halliday Canary, who joins us here today. Please take a moment to thank her for making this phenomenal lecture. We are very honored to have the Honorable Judge Amul Thapar here today to give the Canary Lecture. One of our most prominent faculty members, Professor Jonathan Adler, who's the director of our Burke Center for Environmental Law and the organizer of this event, will tell you more about the judge in his introduction.
Thank you, Jessica. I will be brief because I know none of you are here to listen to me. But it really is an honor to be able to introduce Judge Amul Thapar to all of you today and to welcome him to the law school. He was born in Troy, Michigan, the son of Indian immigrants, raised here in Ohio, in Northwest Ohio, if I recall correctly. BA from Boston College. He received his law degree from the University of California at Berkeley. He clerked for Judge Arthur Spiegel on the Southern District of Ohio and Judge Nathaniel Jones on the Sixth Circuit, the court on which he now sits. He worked in private practice and as an assistant U.S. attorney, both here in Ohio as well as in Washington, D.C. He was confirmed as the U.S. attorney for the Eastern District of Kentucky in 2006. And at the end of 2007, he was confirmed to the Eastern District of Kentucky as a district court judge. Some 10 years later, he was confirmed to the U.S. Court of Appeals for the Sixth Circuit, where he now sits. I could go on with other things, but again, you're not here to hear me. You're here to hear Judge Thapar talk about his book, The People's Justice. So without any further ado, I'm pleased to welcome Judge Amul Thapar.
So I want to thank you for having me. It's a real honor to be here to do the Canary Lecture in honor of Judge Canary, who, like me, was a U.S. attorney and, like me, became a judge, although I would suggest that the state courts are the real courts, and so I would say he was a real judge. And the reason I bring that up is I think too often we get to these prestigious law schools like this one, and we forget that 90% of the American people will never, ever be in federal court. But almost all of them at some point will have interaction with the state court system, whether it's a juror, a witness, hopefully not, but a criminal defendant, where most criminal defendants are. And so I think it's important to remember that. I think as you go through your years reading Supreme Court cases, as you read the media and listen to me today, you remember that maybe the most important courts in the country, and I would suggest without a doubt, are the state courts and the state court system. And so Judge Canary went from being U.S. attorney, which is maybe the greatest job you can ever have as a lawyer, to being a Court of Appeals judge in the state of Ohio, handling very important issues for the people of Ohio. And so it's a real honor to be here. And I looked at the list of speakers today for the first time, even though Jonathan encouraged me to do so when he invited me. I said, no, I'll come. And then he said, you can look at the list. I said, no. So then I looked today, and I recognized one thing, and that is I don't belong on the list, but it's still a treat to be here. So it's a real privilege to talk about The People's Justice, the book I wrote. And people often ask me, why did I write a book, and what was my goal? And so I like to tell the story of the origins of the book, which is I once heard Justice Scalia say that we as judges, as professors who understand originalism, and as lawyers who understand originalism, have the responsibility to fly the flag of originalism. And he, like I, was an originalist, and I am an originalist. And when he used to come in, he used to joke that when he came in and gave a lecture on originalism, everyone would run out of the room like he was a bear. And I think he significantly changed that both in the originalism field and the textualism field to now where I think we stay and we debate the merits of the philosophy. And so what I wanted to do is take the next step and write a book called Originalism for Lay People. That was actually the original title. And I was very proud about 2.5 years ago, or 3 years ago now, I started this venture. And I wrote about 60 pages of the book. And I thought it was fantastic. I talked about the Federalists and Anti-Federalists. I talked about where originalism came from and Brutus's original, the famous Anti-Federalist Brutus, talking about originalism and talking about a judge's responsibility to interpret the document consistent with the original meaning, right in Brutus 15. And then I gave it to my wife. And I still remember the day I'm sitting in the kitchen. So my wife, we have this kitchen, and there's a counter in the kitchen, and she's sitting at it. She always sits in the same chair. And I handed her 60 pages. I was so proud of it, more proud than any opinion I had ever written. I thought it was the greatest thing in the world. She read about 4 pages, and I still remember. She flipped to the 5th page, and then she finally looked up at me, and she said, "Who's going to read this stuff?" So I was back to the drawing board. In that process, though, I recognized something in studying originalism and studying the originalist opinions out of the Supreme Court, something you all probably know, is that Justice Thomas is one of the very true originalists on the court and always adheres to the original meaning. That wasn't really surprising. The next 2 points were surprising, and so I was hoping to capture all 3 by telling the stories of the cases. Second, that Justice Thomas cares passionately about people. And third, that he has a strong black voice that's often covered up by his critics and even those who support him. In fact, you'll rarely hear originalists talk about it. And yet, it shines through in a lot of his opinions. And I'm going to talk about a few of the cases from the book to prove the point. So let me start with a case many of you have probably heard of, which is Kelo versus City of New London. It's the first chapter in the book, and you're going to get why in a minute. Suzette Kelo was a paramedic. She was a woman who was a bit down on her luck. Her last of her children, having just experienced this, I can tell you, it is really down on your luck. Her last of her children graduated from high school and left, and she was an empty nester. Hopefully, unlike my wife, she recognized when the last of her children left what a deadbeat her husband was. And she looked to move out. On a paramedic salary, it wasn't easy. And she wanted, her dream in life was to have a view of the water. So she found a house in the Fort Trumbull neighborhood of New London, Connecticut. She found a house so run down that when she said it was perfect, the real estate agent thought she was on drugs. The real estate agent was embarrassed to sell it to her and said, "I got better houses than this in the same neighborhood. Let me show you." She said, "No, this is perfect." She took the house. And Suzette, through blood, sweat, and tears, rehabbed the house herself. But she also took correspondence courses to become a nurse because she needed more money to keep the house up. And she became a nurse. And through her hard work, her passion, she turned that once run-down house into a beautiful house. She painted it her favorite color, Odessa pink. And as you can see, it doesn't look like a rundown house. And the back, she would come home at night after a hard day on her feet and sit on her back porch and look out over the Thames River. She loved her neighborhood. She loved her neighbors. Her neighbors, directly, I guess, to that side of her, were the Dairys. The Dairys had been in the neighborhood for over 100 years, their family. They loved the neighborhood so much that when their son got married, they put a down payment on a house in the neighborhood as a wedding gift. Most of the people in the neighborhood would buy a house and stay. It was a proud neighborhood, a proud blue-collar neighborhood. Now, I'm going to tell you something. First of all, I put these slides together last night after I sadly got back from a Bengals loss. And second, I have no idea what I'm doing. It's the first time I've ever used a PowerPoint, so I may flip to a slide too early. And if I do, just indulge me, please. So in any event, as she does this, as she gets her house perfect, the other thing you can't see on this house is she puts a sign on it after this that says the Kilo House. She loves it so much. But at the same time she's doing this, trouble is brewing in New London. There's an old mill site down the road. And the city council wants to attract a Fortune 500 company to the old mill site. And they find a natural partner. Does anyone know who it is? Pfizer Corporation. Most of you have heard of them, I think. And Pfizer has a plant across the river, and they figured they'll put one here, not a plant, but a lab, to develop what they believed was their new wonder drug, Viagra. And so Pfizer says, we'll come, but here's what we want. We want a park. We want high-rise condos with views of the water for our executives to live in. We want upscale restaurants. We want a shopping mall. All next to where our labs are going to be, in our offices. And we want it all. And Suzette's Kilo's neighborhood has to go for Pfizer to come. That is basically the quid pro quo. So, the city of New London, the state of Connecticut, and Pfizer Corporation team up, including the governor of Connecticut, who was enthralled with the idea of bringing Pfizer to New London to reinvigorate it. And you can read the chapter. I go into how they use the NLDC, this corporation they set up. But the long and the short of it is everyone thought, all the politicians thought this was a great idea. The chief of staff even put his name on a list of people that would get a condo. Suzette and her neighbors weren't happy. A real estate agent shows up at her house and tells her they're going to take her house one way or another, and gives her an offer the real estate agent says is fair. Slightly more than Suzette paid for it. Suzette says no. Let's see if I do this right. And puts a sign on her house, not for sale. There's the neighborhood. That's the neighborhood they want to take. Suzette and her neighbors say, no way, we're going to fight it. And they find who they think would be the perfect lawyers. The Institute for Justice. The Institute for Justice is a public interest law firm that had just recently made a name for themselves in Atlantic City, where a grandmother's house was trying to be hers and a couple other houses. A casino, in partnership with the government, wanted to take to put in a limousine turnaround area in front of the casino. The Institute for Justice took them on. Anyone know who the casino magnate was? Someone who hasn't read the book. Donald J. Trump. And they won. And so Suzette, the Dairys, and others had heard about it. And they wrote a letter to the Institute for Justice and Scott Bullock. Scott gets thousands of letters. He's a tenacious fighter. In fact, his clients often call him Bull. So he decided when he got their letter to take a trip to New London, Connecticut. couldn't believe his eyes. He couldn't believe this beautiful blue-collar neighborhood, Pfizer, and the city and the state were trying to take. So he signed up for the case, and he asked the city to not exercise their eminent domain power. Now, eminent domain, as you all know, is found in the Fifth Amendment. It allows the government to take your property for public use with just compensation. That's what it says. Of course, we all know that compensation's never just, and public use has been changed by the Supreme Court. So, Scott knew he had an uphill fight. Let's see. So, in the 1950s, the District of Columbia City Council decided, this is the Supreme Court case, that they wanted to take this neighborhood, the most integrated neighborhood in the District of Columbia, away and hand it over to private developers because they were not getting enough tax compensation and other things in a case called Berman. And the District of Columbia wanted to give it to private developers for apartments, for housing, obviously, for shops. Some of the store owners from the street, Fourth, challenged it. And it went to the United States Supreme Court. And in that case, the Supreme Court said that the city may take this neighborhood for because it served a public purpose. Notice the change in words. From public use, the words in the Constitution, to public purpose. So Scott fought this on behalf of his clients. On the night before Thanksgiving, the city posted a notice on Suzette's house, the one that was not for sale, saying they were taking her house through eminent domain. And to add insult to injury, she had to start paying rent. She called Scott, and he filed a TRO to stop the city from taking the house. The 30-day period, the court set by Connecticut law, they could take the house 30 days later, after the notice. The 30-day period, the court set the hearing on the 31st day. Scott asked to expedite it. The court said no. One of the residents of New London had ripped out the inside of his house to rehab it and was starting the rehab process. The night before the hearing, they were worried they would bulldoze that house. In the middle of December, some of the lawyers and some of the residents slept in that house because of the worry. They thought if New London and the government started bulldozing these houses, hope would be lost. They fought this case, and it went through the state courts. Remember what I said at the beginning. They ultimately lost in significant part at each turn and ended up in the U.S. Supreme Court. Now, if I really knew what I was doing with PowerPoint, this PowerPoint, I promise, is going to get better. I would have this argument clip in it so I could hit it and it would play. Can you do that with PowerPoint? I imagine you can. Okay, so you can teach an old dog new tricks. The fact that I actually did this much is impressive, and I'm going to show it to my kids because they'll never believe it. But it gets to the Supreme Court. And Justice Scalia asks the city, can you take from the poor? They're diving into public purpose. Can you take from the poor and give to the rich because the rich pay more taxes? That would serve a public purpose. Can you do it? City's lawyer, much to Justice Scalia's shock, says yes. Justice Scalia then says, are you serious? You can take from A and give to B because B pays more taxes. And the city's lawyer doubles down and basically says, yes. The case ultimately, after the argument, there's Suzette with Scott Bullock at her side, hopeful that she will be able to keep her house and stay in her neighborhood. She loses 5-4. Justice O'Connor writes the principal dissent, joined by Chief Justice Rehnquist, Justice Scalia, and Justice Thomas. She argues basically, in not so many words, that this is not a public purpose. It is a private purpose, and a private purpose does not qualify under Berman. That was the take the Institute for Justice took, because they didn't think they could get 5 votes to return to the original meaning. There are about 130 amicus briefs in this. I combed many of them, not all of them, and I found one organization asking the Supreme Court to return to the original meaning. Does anyone that hasn't read the chapter or heard me talk about it know what that organization is? The NAACP. The NAACP argued that eminent domain historically had a very bad pedigree. They had quotes in there that I won't repeat, some of which I put in the book, from government officials about eminent domain. And they pointed out the disparate impact it has on poor and minorities. They argued that you should go back to the original meaning public use. What is a public use? As Justice Thomas in his separate writing points out, a public use historically was taking a sliver of your land to widen a road, something the public would actually use, or putting a sidewalk on your land, something the public would use, or railroads perhaps, something the public would use. It wasn't wiping out an entire community, whether the community in DC or the community in New London. Justice Thomas also pointed out that in Berman, 97% of the people displaced were black. That eminent domain had a racist origin with the way it was used, and that the term used for it, again, one I won't repeat, but you can read in Justice Thomas's dissent, the NAACP's brief, or the book, was problematic, and the court should pay attention to it. That when we get away from the original meaning, it often harms the most vulnerable and the most powerless communities. His quote, which I think is important to read because I think it really puts forward what he was getting at, and I'm quoting, "Something has gone seriously awry with this court's interpretation of the Constitution," Justice Thomas warned, "when, though citizens are safe from government in their homes, the homes themselves are not safe." He pointed out the problems in cities where it had been used and how it had often been used to displace poor and minorities. The majority had said they should defer to the government on what was a public purpose because the government would know best. Justice Thomas pointed out we don't defer to the government on whether a search is reasonable because they know best, nor should we defer to the government on whether something qualifies under the Constitution. After Pfizer moved in, the neighborhood was wiped out, and Pfizer stayed for 8 years. Okay, how come I can't make it work now? What did I do? Oh, I went to New London. Oops, went too far. Uh-oh. There we go. That, today, is the Fort Trumbull neighborhood. You can see the view Suzette had. That's what's there today. The wonder drug didn't work. Pfizer left. And the city no longer has the 100-year-old neighborhood. It has a field where feral cats and rubble occupy it. Okay, for the next one, who knows what this is? The Cuyahoga River. I got to talk about Cleveland when I'm in Cleveland, right? So in the early 70s, a young man from Cleveland wanted to run for mayor. The city was down on its luck. It had been coined by one national publication, the mistake by the lake. In Cincinnati, we still call it that. I'm just kidding. The Cuyahoga River had caught on fire. That's like the exclamation, right? The community was destitute. Problems abounded. George Voinovich, who grew up here and went to public schooling here, wanted to run for mayor. He wanted to change the city's fortunes. And he ran and lost. But as we all know, after that first election, he didn't give up. He ran again. Next time he had an opportunity, and he won. At the time he won, the public standing and the people of Cleveland were in despair. He turned around the city by bringing and lobbying to bring that. He raised taxes to get tax money with the city's approval and brought national attractions to the city of Cleveland, including something I'm sure you're all proud of, the Rock and Roll Hall of Fame. He built a new basketball arena that LeBron James would ultimately occupy and bring a championship. He did all sorts of positive things for the city of Cleveland. So much so that when he ran again, he won with around 70%. And I might even be wrong of the vote. It's in the book. I'm sorry if I got it wrong. And eventually, as we all know, he ran for governor. But when he got to Columbus, even though the city of Cleveland was thriving, he knew the children of Cleveland were not. At around the same time as he left, maybe a little before that, between 14 and 25 public school buildings had been condemned. The Board of Education did nothing about it for 3 years, so much so that in 1995, a federal court had to order that the public schools be turned over to the superintendent of the state of Ohio. When George Voinovich got to Columbus, he decided that he still owed it to Cleveland to clean up the one thing he could not, the schools. So he partnered with David Brennan. Now, David Brennan was an interesting guy. He and Voinovich didn't agree too often. Brennan was a business owner. Brennan recognized in running a business that people were not progressing in his own business at the rate he understood. He figured out quickly it was because of illiteracy and set up education programs within his company. So Voinovich tapped Brennan to explore the problem. And the problem was even worse than they anticipated. Only 9% of Cleveland students passed the Ohio proficiency exam, public school students. Only about 25% were even graduating high school. The numbers were stark. And Brennan and Voinovich decided, as you all probably know, that vouchers were a temporary solution to a bigger problem. So they tapped Bill Batchelder, who was the leader of the Ohio Senate, to put in place a voucher program. Or maybe he was speaker, I'm sorry. And Bill started to explore how to do so. And he came to Cleveland and he met with the city council members, including my favorite person in the book, Fannie Lewis. Now let me tell you, a lot of you are nodding, so you knew who Fannie Lewis was. She was a truly amazing woman, a public servant in every sense of the word. All of our politicians would do well to model themselves after Fannie Lewis. A product herself of the public schools, although not of Cleveland. She came from the South, Memphis, I believe. She came to Cleveland and lived in the Huff neighborhood, which is one of the lowest income neighborhoods in Cleveland. And she was not afraid to share her mind. And share her mind she often did. She made a name for herself during the riots when the National Guard came in, and she policed not only the citizens, but the National Guard itself, single-handedly. Her picture was pictured there talking to a National Guardsman and featured in the media. She was a big critic of city council, but eventually ran for it herself. But here's the thing about Fannie Lewis. When she walked through the neighborhood, this is my favorite quote in the book. They said, Fannie Lewis is the safest person in her neighborhood. One of the roughest areas of Cleveland. The reason is she knew everyone. If you jumped her, she'd call your mom. That's how much she cared about the community. And she was willing to put the students first. So she, Bill Patman, and other city councilmen and women teamed up with Bill Batchelder, but they needed private schools to take them. Ironically, when Bill went to the suburban schools, they said no, they won't take the vouchers. So Fannie Lewis had an idea. Meet with Bishop Pilla. Bishop Pilla was a huge fan of Fannie Lewis's, not surprisingly, and Bill Patman's. And so they took Bill Batchelder to meet with the bishop. And the bishop agreed to include what I believe is about 46 Catholic schools in the greater Cleveland area in the voucher program. So, Bill Batchelder designed the voucher program such that he believed it could withstand constitutional scrutiny. How did he do it? He designed the vouchers to go to the parents, and they could pick one of four things. They could pick to get a voucher for tutoring and stay in the public schools as they existed. They could pick to get a voucher for the community schools. They could pick to get a voucher for the magnet schools, or they could get a voucher for private schools. The first three, the state would pay directly. For the private schools, the voucher would go to the parents. It was $2,250, and the parents would have to pay $250 out of pocket. And the private schools agreed to take a $2,500 voucher. The program was immediately challenged. First in the state courts. It goes through the state court system, ultimately gets approved with slight modifications by the Ohio Supreme Court. Then, on the day the day before school started, the federal court in Cleveland suspends the program. As the Baltimore Sun said, parents were in disbelief. They had planned to send their kids. Some of them were going for their second year. They didn't want to send them back to public schools that in many places lacked toilet paper and soap and basic necessities. They weren't safe, as the parents said. Nonetheless, the federal court suspended the program. Bishop Pilla agreed to pay for all of the students during the challenges. And the archdiocese here funded it until they could get it stayed. They ultimately got the district court ruling stayed by the United States Supreme Court. Judy French was tapped when this case went to the Supreme Court to argue it. They lost in the district court and lost in the Sixth Circuit. She was tapped to argue it. She worked for Betty Montgomery in the Attorney General's office. Judy French was a young lawyer at the time, in her late 30s, and herself a product of public schools. She was a single mom and sent her 12-year-old daughter, 11-year-old daughter, I think, actually, to public schools in Columbus. She didn't understand the problem. So she came to Cleveland and met with the parents. She wanted to know, were the parents sending their kids to Catholic schools because of religion or for other reasons? The parents mentioned safety, improved test scores, where most of their kids were now thriving, and the additional tutoring programs that existed in the Catholic schools when you fell behind. So Judy French then became the advocate for the program in the US Supreme Court. As she prepped, so why is Gladiator up there? She would prepare to the music of Gladiator. When she got to DC to argue the case, there was a lot of consternation. Her partner in prepping the case was Ken Starr, the famous Solicitor General, Whitewater Counsel. Most people wanted Ken Starr to argue the case, but not Betty Montgomery. People were up in arms that a relative rookie was going to argue the case. Also, a woman, to be candid, was going to argue the case at a time when many women, and still, there aren't very many Lisa Blatts in the world regularly appearing in front of the Supreme Court. But Betty Montgomery was adamant. Judy French had to go through 8 to 10 moot courts just to pacify people. People would call Ken Starr and say, "Will you please step in?" And he said, "No, she's the woman for the job." Now, for the young law students and others, anyone that advocates, I would recommend you go listen to Judy French's argument. I listened to it in preparation for this book. I was blown away. It's one of the best Supreme Court arguments I've ever heard. A relative rookie got up and delivered one of what a lot of people thought was the most important arguments, and as we all know, won the voucher case in the US Supreme Court. She won 5-4, and Chief Justice Rehnquist wrote the majority, and you can again read it or read the book to get the details. I'm going to give you just a few snippets of Justice Thomas's separate writing. He wrote separately. He started, as he often does in his opinions, and ended with the words of Frederick Douglass. Words he himself had heard as he grew up. Education means emancipation. Those are the words of Frederick Douglass. When he was a young boy, Clarence Thomas, his mom made $10 a week. She couldn't afford to raise a young Clarence and his brother, so as many people know, she handed them to their grandfather. Their grandfather had a third-grade education, but he understood that the one way out was through education. And so he saved every penny he had to send a young Clarence and his brother to Catholic schools. They were segregated in the South at the time Clarence Thomas was growing up, but they were K through 8. He went K through 8 to Catholic schools, then to a Catholic high school. And Justice Thomas credits this more than any other education he got with being critical at setting him up on a path for success. He points out in his separate writing, sorry, I had it marked and I grabbed the wrong book, that the Cleveland Public Schools failures disproportionately affected minority children most in need of educational opportunity. At the time of Reconstruction, blacks considered public education a matter of personal liberation and a necessary function of a free society. A century and a half later, the promise of public school education had failed poor inner city blacks. That is why he points out that many parents and others, blacks and minorities, supported school choice programs. Then he quotes, while the romanticized ideal of universal public education resonates with the cognoscenti who oppose vouchers, poor urban families just want the best education for their children, who will certainly need it to function in our high-tech and advanced society. And, what'd I do? Okay, I'm back to that. There it is. That is the view the day the case was argued in front of the Supreme Court. Most of the Cleveland parents made a trip up there to show their support for the program. At the end of his opinion, Justice Thomas noted that these programs allowed children to escape the failing urban public schools where so many attempted reforms had fallen short. He gave Frederick Douglass the last word, as I mentioned. No greater benefit can be bestowed upon a long benighted people than giving to them, as we are here earnestly this day endeavoring to do, the means of an education. How are we doing on time? 5? Okay, I'm going to do one more case. I'm going to go super quick, all right? Because I want to do this case, and I promise I'm going to go quick. Okay, wait, I'm going to skip this one, and I'm going to do this one, because the other one will take me too long. The other one was Morales. Most of you probably know it. So this is Kathy McKee. Kathy McKee was someone who at 16 years old went to Hollywood on a one-way bus ticket with enough to afford a hotel for one night. She had plans, like so many young boys and girls, to become a star. And you can read the chapter as to how she became a star. She became a star. On the left is a show called Sanford and Son. And then she toured with Sammy Davis Jr. During that tour, she ends up in Detroit, her hometown. And when Sammy Davis has to fly back, she decides to stay. She bumps into another friend whose show she appeared on, Bill Cosby. And Cosby invites her out. I'm going to skip what happened because hopefully we all know it. She, like so many women who get raped, suppresses it. How can she challenge, she thinks, America's dad? Who's going to believe her? You can read about her successful career in the chapter, but about 30 years later, as we all know, she finds out she's not alone. And women come out and start saying what happened to them and what Bill Cosby did. Many women. What does Cosby do? Him and his lawyers go after the women with a scorched earth policy of attacking them. Kathy, who is incredibly brave, has had enough. So she speaks to reporters as well. Then when Cosby and his lawyers come after her, she wants to sue. She wants to sue not for the rape, which statute of limitations has run, but for defamation. She wants to prove that she's telling the truth, and these women are telling the truth, and Cosby is not. Why can't she sue? What case keeps her out of court? Who knows? Someone said it? Who said it? New York Times v. Sullivan. New York Times v. Sullivan and its progeny made her by accusing Cosby of rape a limited public figure, which means she had to prove the actual malice standard. Her case gets to the Supreme Court. Long story short, Justice Thomas writes separately. We all know what he does. He points out there's no original meaning, that under the original meaning of the Constitution, New York Times v. Sullivan is not supported and has no bearing in the Constitution. And I'm going to cut to the ultimate chase. I'd love to read to you how he thinks New York Times v. Sullivan is masquerading as a charade. He writes all that and lays out all the state laws that regulated defamation at the founding and thereafter, and until New York Times v. Sullivan. And then, as we all know, every time he gets a chance, he writes about New York Times v. Sullivan. And he never forgets about Kathy McKee. Indeed, 2 years later, in a separate writing, in a separate decision about New York Times v. Sullivan, he points out, he reminds the court once again that Sullivan, and I'm quoting, had denied McKee the right to defend her reputation in court simply because she accused a powerful man of rape. The unintended consequences of getting away from the original meaning. I don't think anyone on the court envisioned, that wrote or participated in New York Times v. Sullivan, that Kathy McKee would be prevented from protecting her reputation. And yet, that is the unintended consequences of getting away from the original meaning. That's what this book is about. Thank you very much.
We have a few minutes for questions. Also, when the lecture concludes, we'll be having a reception. Those of you that have been here before are probably used to the reception being in the lower rotunda on the other side of this wall. We now do them upstairs in Ben's place, so just up the stairs that are right over there. There will also be an opportunity for a book signing for those that are interested. I'm going to take the moderator's prerogative and ask the first question. In the book, you talk about how Justice Thomas, in a lot of these cases, spends time talking about the parties in the case or those who were affected by the rules in the case. How would you respond to the concern that in at least some areas of the law, and I ask this in part because you yourself were a former prosecutor, he seems to be more concerned about, or show more concern about the victims of crime than perhaps the victims of criminal law enforcement, including cases like qualified immunity?
So I would say, he follows the law wherever it leads. I think if you look at cases like Alene, real quick, is about mandatory minimums. Justice Thomas believes that historically sentencing was done by juries. And so for mandatory minimums, he wrote the opinion saying that judges could not impose mandatory minimums without juries making threshold findings. Obviously, Booker and its progeny that threw out the mandatory sentencing guidelines. So he does those types of things. But yes, there's a chapter in the book, Brumfield, where Justice Thomas talks about the impact and the devastation that Brumfield's family wrought on Warwick Dunn's family when he killed Warwick Dunn, the famous running back's mother, when Warwick Dunn was 18 years old and one of 6 children, and how Warwick Dunn then had to raise his siblings, and Justice Thomas talks about that and definitely understands the plight of victims. Morales, I wanted to get into it. I didn't have time, but I think maybe that deals with, as he says, the 98% that are terrorized by the 2%.
Okay, folks have questions, just want to wait for the microphone so that they can be picked up by the camera. So, go right over here.
First of all, Judge, welcome to Cleveland.
Thank you.
How does the legal ideology of originalism fight for the little guy, as you say in your book, and restrict government tyranny and overreach?
So I think if you go through the basis cases in the book, you see it firsthand. Whether it's Kelo, where we have, which I talked about, government overreach and the little guy. Zellman, you could argue, is for those impoverished that can't make the decisions. Patrick Sweeney, the ranking Democrat who partnered with Bill Batchelder to get vouchers through, said the only people who oppose vouchers are those who have a voucher in their pocket. And so I think you see it there. I think throughout the book, when you talk about someone I was surprised by, the fourth chapter is a case called Raich v. Gonzalez. And Angel Raich was someone who was really suffering intense pain and used medical marijuana. Justice Thomas, of course, wrote the dissent saying that the federal government should not be able to regulate growing marijuana in your own home for your personal use. That's not interstate commerce, according to Justice Thomas. Obviously, the Supreme Court's taken a different view on that. And so in many ways, and I could go through chapter by chapter to respond, but I do think that most often when you follow, so the document, meaning the Constitution itself, now I'm going to get into my old book, which thank God my wife's not here, but the Anti-Federalists really were concerned about government tyranny and championed the Bill of Rights. In fact, many people, including Justice Scalia, who I discussed this with and he disagreed with me, he said, Amul, why do you pay attention to the losers in the debate? And my point is, A, I read both briefs all the time, and he should have read both, but also that the Anti-Federalists were the winners according for when it comes to the Bill of Rights, and many of the Bill of Rights are meant to do just that, whether you look at the Fourth Amendment, in my opinion, the First Amendment, and many others. Thank you.
Other questions just for wait for the mic real quick.
Real quickly.
Hold on just for the mic. I'm sorry. Just because he said it. You speak like me. I don't know that we need mics.
The question that I have is, why is Clarence Thomas perceived in the minority community as an enemy as opposed to some of the revelatory information you gave us today?
Yeah, so I think that's a great question, and I wish I knew the answer. The thing is since the day he came on the court, one of the remarkable things about him, so Justice Thomas, I want to give a twofold answer. When Justice Sotomayor came on the court, she said her personal experiences mattered. And I don't know if you remember, but a lot of people criticized her for that. I think anyone that's been a judge knows your personal experiences matter. I think it's ridiculous to say they don't. Justice Thomas is evidence of that in my mind. He went to a segregated school. From the day he's been on the court, he's been a champion of historically black colleges. One of the great quotes of his that I love is in one of those cases, Missouri v. Jenkins, he says, "It never ceases to amaze me that the courts assume that anything that is predominantly black is inferior." And I'm quoting Justice Thomas. But he often has championed historically black colleges. We saw it again in Students for Fair Admission, where he pointed out the statistics. 80% of federal judges went to a historically black college, or 80% of judges. 50% of all black doctors went to a historically black college. 40% of all black engineers went to a historically black college. Those are remarkable numbers. Justice Thomas has championed that since then. He's championed in the cases I brought up, but other cases. He talks about in Virginia v. Black, a case about, I didn't even mean to hit it, so it happened. Barry Black, the Klansman, burns a flag. Or burns not a flag, I'm looking at the flag, burns a cross. Justice Thomas, go read his separate writing. He talks about the reign of terror that the Klan had wrought. It caused me to go back and study the history of the Klan. Something I didn't realize, but Justice Thomas has pointed out, and others, is Woodrow Wilson really brought the Klan back onto the forefront, believe it or not, by showing a movie in the White House called, I think it's Birth of a Nation. And so I think it's really, to me, after studying his jurisprudence in a way that you usually don't study, I was shocked at how strong his voice is and how much that's lost. I think it's lost because neither side wants people to hear about it. I wish I could point to one side or the other, but I think it's both sides. And I didn't even mean to hit the button, by the way, but there he is, Barry Black. And I called it 3 Men and a Cross because I just got to say this. There's the field he burned a cross in, and this guy, David Baugh, defended him. David Baugh is a remarkable lawyer for all of you out there. He defended a very unpopular person because he believed so much in the First Amendment. And David Baugh is the son of a Tuskegee Airman and a champion of historically black colleges. And when the government wanted to integrate his historically black college, he protested. So it's really interesting, and I got to read the end of the chapter. I'm proud of this just because I wrote it, but the end of the chapter, I pointed this out. In the end, burning the cross represented three very different things to these three very different men. To black, it was a symbol of white supremacy. To Baugh, the burning cross marked the outer limit of speech protected by the Constitution. To Justice Thomas, there's the courthouse he was tried in, by the way. To Justice Thomas, I can't do this. Of course, I can't make it work, so I give up. But to Justice Thomas, it was, and in American society, always necessarily would be, a hateful act of intimidation and terror. In fact, you'll remember, and I'll finish with this, Virginia v. Black, after Justice Thomas had remained silent for many years, he asked questions of the government in Virginia v. Black. Thank you all very much.